Hello, I think we are live. Welcome to today's webinar, Gibraltar, the go-to destination for international fintech startups. My name is James Wood. I'm editor at the Legal 500, but today we'll be hearing from three people far more qualified than I to discuss the fintech startup scene in Gibraltar, namely Anthony Provasoli, Aaron Payas, and Selwyn Figueras, three of the partners at Hassan's international law firm. The three of them have collective expertise in fintech, crypto, and distributed ledger technology. And that expertise will be hugely important here, as we're going to hear in just a moment about the distinctive Gibraltar approach to distributed ledger technology. And it's an approach that has been used to offer the golden triumvirate of legal, tax, and regulatory certainty. Now, as I'm sure you all know in the audience, Hassan's is not only the largest law firm in Gibraltar, but they're also the market leaders when it comes to serving tech and financial services sector clients. Indeed, they're the only firm the Legal 500 recognises in Gibraltar as Tier 1 for fintech. So it's a great privilege to have them here to discuss this topic today. Before I introduce our three speakers, I do want to remind you in the audience that we're keen to hear your thoughts and questions. So if you have anything you're struggling with or anything you'd like to get the partner's thoughts on, please do submit using the Q&A function or the chat function, and I'll try to put as many of those questions as possible to the partners at the end of the discussion. Okay, well, I will first introduce Selwyn Figueras, a partner at Hassan's. Selwyn is a UK qualified barrister with a full range of relevant and complementary skills in IT, legal tech, network development, and relationship management. His areas of expertise are, among other things, cryptocurrency, DLT regulation, corporate finance, finance restructuring, tax planning, Gibraltar gaming laws, licensing, and regulation, and a host of other things. He was a member of the Gibraltar Parliament from 2011 to 2015 and was a core team member working alongside Fabian Picardo, who was leader of the GSLP Liberal Alliance and now third-term Chief Minister of Gibraltar. So a wealth of expertise. Selwyn, do you want to give us a quick hello so people know who you are?
Hello, hi, thank you very much for joining us.
Okay, excellent. We will also be hearing from Anthony Provasoli. Anthony is a partner in Hassan's fintech team. He has particular expertise in distributed ledger technology and virtual assets. He's been advising on cryptocurrency and blockchain related work since 2014 and was very much involved in promoting the regulation of cryptocurrency based businesses or related businesses in Gibraltar. He's done a whole host of important work in the sector, both in Gibraltar and at a European level, so a great person to have here. He's also a regular speaker on blockchain and fintech events across the world. So Anthony, do you want to say a quick hello so we know who you are?
Thank you.
Cool. Last but not least, Aaron Payas, who is CFO partner at Hassan's. His practice, as with the others, is focused on fintech and particularly looks at leveraging the advantages Gibraltar offers as a proof of concept jurisdiction in financial services. So again, hugely important part of the presentation today. He has been instrumental in many of his clients' achievements in getting distributed ledger technology projects off the ground. He assisted in the creation of the first 3 regulated crypto funds in Gibraltar. And he has also assisted in the listing of a Canadian-based fund called the Bitcoin Fund, which I'm sure we all know. That was its second listing on the Gibraltar Stock Exchange. And I think only the second of its kind ever to be listed in the EU. So again, hugely expert and very relevant to this. So Aaron, do you want to say a quick hello so we know who you are?
Hello, everyone. Thanks for joining.
Excellent, great. Well, I'm sure I've missed a lot of important information out of your bios there, gentlemen. So perhaps now is the time to hand over and you can fill in any blanks or add any information you want.
Thank you. Thank you very much, James. It's a pleasure for us to be here today. It's always great to be speaking and working with the Legal 500 on these events. And we hope you'll take away some important insights as to where we are as a jurisdiction today on the DLT front. But I think it's probably a good idea to touch very briefly on what the background is and how we are where we are today. Gibraltar has been leading the way in the context of blockchain, crypto, the wider DLT space for some time now, and some time now in this world means the last 7 to 8 years since the inception of the program and the working group that created the environment here in Gibraltar, where we now have a good number, I'm not sure the number of DLT operators fully licensed to operate in Gibraltar, and the detail of the work that we're doing is something that both Anthony and Aaron are going to speak about in a wider context. It's important to understand that the approach to crypto in Gibraltar has always been that we do not seek to regulate crypto, but we seek to regulate activities which use crypto, which fall within the remit of financial services at this stage, and that is why the focus for the time being here and for the foreseeable future is on regulating activity in financial services using the DLT. We were here 25 years ago again when we were developing the gaming regulatory space, where Gibraltar was also a leader. And we created what we consider is probably the most prestigious gaming regulatory environment in the world, where most of the most important players are based, and for good reason. And then we saw the opportunity to emulate what we had done in the gaming context with crypto as well. And very early on, in 2015, 2016, as a working group came together, it was understood very quickly that we needed to move with this developing area, and it's been obviously extremely dynamic. It's been nothing like gaming in terms of the pace at which it has developed. But I think we've managed to find a good balance between the competing interests, as one might put it in this context, and that is protecting the rights of the users, ultimately promoting and enabling entrepreneurs to develop these programs and do well out of them, and of course to protect the reputation of Gibraltar as a finance center too, which is one of the key objectives. So as we'll touch upon in more detail, what I think Gibraltar offers above everything else is the compelling triad of legal, tax, and regulatory certainty. And again, the details will cover by referring to some case studies. Aaron will be talking about crypto foundations and funds as well, whereas Anthony will be focusing on the regulatory advisory side of things, which is obviously very interesting. And I thought I'd touch, before moving on to Anthony, to introduce the various different kinds of work that we're doing in this space. And actually it's quite a long and colourful list of different kinds of work that we're doing in this field. I thought it was also very important to touch upon something that might or might not be on the minds of viewers, and that is where we might be in the context of Brexit and how it has impacted on us. For a long time, and still today, in the crypto context, we are Brexit agnostic. And so because there's no European regulatory space where we were operating before, that suddenly no longer applies. We don't find ourselves in that position. I think the more important elements for Brexit for us are based on the negotiations as they are happening now, and we hope to see an end to a good conclusion to in March. We see an opportunity for Gibraltar again to position itself as a jurisdiction that offers market access to the UK in a way that is unique to the foreign overseas territories, but also maintaining a Schengen type arrangement whereby we will have a fluidity of movement across the border for people working here and throughout the Schengen area. Any questions that arise in relation to that, please feel free to post them on the Q&A or on the chat, whichever you feel most comfortable with. And I'll be very, very happy to deal as specifically as you'd like me to with those issues. It's hard to talk about it in general terms without commandeering the whole of the session, which is something I don't want to do. And so having covered that, I think it's important to stress that Gibraltar's position post-Brexit is that whilst we're no longer in Europe and we do provide this access to the UK, we are still, of course, European in terms of our location, in terms of where we've come so far, except for the last 2 years. And we can offer assistance and insight in cross-market activity too, which is very, very important. So what I'd like to do now is to hand over to Anthony to talk about the various different kinds of activity that we're involved in, and then we'll start to drill down, I think, into the detail of some of the more interesting elements of that work. Anthony, over to you.
Thanks, Selwyn. Just to touch on some of the things that Selwyn said there, and to give you a little bit of background as to how Gibraltar became a hub for this type of activity. And it goes back to probably 2014, 2015, when we first were approached by a client that was interested in setting up an exchange, which was a Bitcoin exchange at the time, because it was the only cryptocurrency that existed. Obviously, there's thousands now, but at the time it was only Bitcoin. And when we received that inquiry, I was a lawyer in the financial services industry. Probably around maybe 8-9 years qualified at the time, and this was crypto, blockchain. This was all completely new to me. So I started looking into it in a bit more detail. It sort of looked like it should be within the realms of financial services. So started asking, obviously, the other partners at the firm, and the other lawyers who worked in the team, and not many people knew what I was talking about. In fact, nobody knew what I was talking about. And but even outside of the firm, speaking to the regulators, the banks, the other professional advisors, nobody really knew what I was talking about, or even cared, really. So I found it hard at first to sort of be able to speak to anybody about it, because of the lack of knowledge, but also the lack of material that was online, and the fact that a lot of people were dismissing it as potentially something that was very closely linked to illicit activity, or criminals were using these type of assets, money launderers, this type of thing. So obviously it was difficult to sort of get a lot of information, not just from people, but also from material, from sources online, and things like that. I then eventually was invited to an event in the Isle of Man, I think it was, and this was when I first realized that this was a real industry, in fact, and that there was a lot of legitimate businesses, and a lot of opportunity within the industry that I thought some jurisdictions could exploit, because at the time there was just nobody paying any attention to it. So thankfully, Gibraltar, we came back, we spoke to the relevant, to the government, to the regulators, and thankfully it was something that was of interest, and as happens in Gibraltar, and I assume other smaller type of jurisdictions, you're able to sort of influence how certain sort of policy decisions are made. So we were able to effectively the government put together a working group that really focused on what the potential could be here, and if we did decide to regulate it, we would be the first jurisdiction, or at least one of the first in the world, to really be looking at this and designing bespoke regulations for this type of activity. So there was nowhere to look to there was no other model to try and compare to, or copy, or so really the starting point was a blank canvas. Very important was that we got technical experts involved in the preparation, in the writing, and the designing of that regulatory framework, because obviously if the regulator doesn't understand what the potential opportunities or pitfalls may be within the of using this type of technology and the assets that were around, you can't really design something that works, and therefore we were very careful to make sure that we had a team that was very experienced, qualified, to be able to be providing valuable input and valuable insight into how a regulatory framework of around this industry could be designed. So anyway, what we have today is Selwyn mentioned it before, legal certainty, and that is one of our real strong points as a jurisdiction, and it's one of the things that attracts DLT companies, crypto firms, because there is so much uncertainty around the world, given that it's largely an unregulated industry, that people want to have that comfort that what they're doing is actually within the scope of the law, within the parameters of the law. If there is a regulatory framework that they can sort of operate within, then that is obviously seen as a positive thing. So I would say that legal certainty is obviously paramount, and within that framework we have the DLT regulations, which came into force in January of 2018, and we have it's a tried and tested model. There's 15 licensees that are today regulated by the FSC in the DLT and crypto space, and there's a pipeline of at least another 15 that we know of, because we're involved in a number of applications. As well as the DLT framework, we have now what's recently been introduced is the VASP registration regulations, which were designed following the FATF guidelines around anti-money laundering, and it was designed to capture effectively service providers, virtual asset service providers that otherwise fell outside of the scope of the DLT regulations. Remember that in 2016, 2017, when the DLT regulations were put together, things like ICOs were not a thing, token sales were not a thing. DeFi was something that is now a buzzword, and there's a lot of applications around decentralized finance which are coming to the fore. Things like staking, all of these things didn't exist back then. And again, in an industry that is so fast moving, it's important that regulators don't stand still and keep on moving with the times, because obviously new products are going to come out, and service providers want to offer those products because there's the demand for them. So anyway, the VASP registration regulations were created to sort of mop up those other service providers which otherwise fell outside of the scope of the DLT regulations. The other two things that I would say are very important to the jurisdiction, and it's sort of and sort of instrumental to it being deemed a hub, a successful industry in jurisdiction in this industry, are the knowledge and understanding of the regulator. So the fact that the regulator, you're able to first, obviously, they have to be very approachable, because there's the industry, again, going back to what we said earlier, is so fast paced. They need to be, the regulator here is willing to sit down, speak to applicants about their business model, their products, what they want to offer. And it's refreshing when you speak to a regulator and they understand what you're talking about, and it doesn't feel like you're talking to an alien or even a police officer that's trying to sort of pick holes in your armor. It's they're really there to understand what you're doing and to try and help you get over the line, and to try and help you provide your services and your offering in a manner that is as safe and safe to the consumer, but also safe for the jurisdiction. And the last thing I would say is very important to us is the professional expertise that's been developed in Gibraltar. So, not just advisors, legal advisors, accountants, but the banks. You go to a bank and you talk to them about your business, and you're providing services around cryptocurrency, and the banks actually know what you're talking about. They know, they know what sort of questions to ask. They know what the potential risks are. So they do understand your business model. They do understand what you're talking about, and I think that's extremely important as well. So I would say those are the things that sort of make Gibraltar a powerhouse in this industry. And again, moving on to some of the sort of types of work that we would normally be involved with, it's very sort of expansive. So we'll advise on regulatory issues So obviously, every time somebody comes to us, they'll come with their product. This is what we want to do. This is what, this is how we want to operate. And we'll say, okay, these are the potential regulatory implications. These are the things you need to look out for. And to the extent we think, look, this is potentially falls within the scope of our regulatory framework here, we'll then put together a presentation, a business plan, and approach the regulator with it. Obviously, if it does go down that route and we do deem that this activity is regulated activity, we'll help them with the applications. So we'll assist throughout the process. And that can include everything from, dealing with the regulator, preparing the documents that form part of the application pack. And obviously things like, then, it gets into things like intergroup agreements, contracts, lease arrangements for office space, employment contracts, registration of or relocation of founders or key workers to the jurisdiction, those sort of things. So obviously there's a big array of different areas of law that would be covered eventually by from the whole process, from start to finish. The other thing that we also advise on, and my colleague Aaron is now going to expand on, is foundations, crypto funds, and of course token sales. So and token sales can be obviously either tokens which are deemed financial instruments, in which case they're known in the industry as security tokens, or what are known in the industry as utility tokens, which effectively are assets that are not deemed financial instruments within the definition as set out in the Financial Services Act here. So yeah, without further ado, I'd like to pass on to Aaron to talk a bit more about those things.
Thank you, Anthony. Yeah, and I think just to finish up on that point, with the regulator particularly, one of the benefits of Gibraltar is how close the industry is to the regulator. So we hold at least monthly meetings with different members of the regulator, and that can be extremely helpful in an industry such as crypto, because there's always something new. There's always legal issues thrown up by a new project, by a new DLT, because not all of them are blockchains now. So that I feel is very important. And also I think the main reason why we have been able to develop so quickly as a firm and as a jurisdiction is because of the amount of work and the amount of different projects that we have worked on. So crypto is difficult to understand by default, but even if you learn it, unless you put it into practice, there's always going to be a lack of understanding. And the benefit that we've had as a firm is that we have dealt with so many different projects, so many different issues, real world problems, real people behind projects. And I feel that's what's driven us to be where we are now as leaders in this market, and as a jurisdiction. We've become a premier crypto hub. And I would say also we've in Gibraltar, and we'll cover some of this in detail, so we've got the crypto funds, we've got the foundations, we've got research and development companies, we've got founders moving over, setting up shop here. We have the Gibraltar Association for New Technologies, so we have an industry association that lobbies on behalf of the stakeholders, lobbies with the government, lobbies with the regulator. We have a chapter of Startup Grind here in Gibraltar, which again, as a proof of concept jurisdiction, is a very important piece. This last week we had the announcement by Valerium PLC, that's a company, a public listed company in the Aquis Exchange in London, notifying that or announcing that they will be accelerating the buyout of shares up to 90% of the Gibraltar Stock Exchange, and again with a view to creating a market that bridges the fiat and the crypto markets. So the ecosystem, not only the expertise, the ecosystem is also growing, which helps us develop as practitioners, and together helps us improve or develop what the jurisdiction can offer. And in terms of what we can offer, there's so many different things. Focusing on funds, we set up the first regulated crypto funds back in 2018, so very, very early on. These funds can be set up as private funds, so your traditional friends and family funds, but also under our experienced investor fund regime, we can set them up as regulated funds, with the additional option that if we want to set them up as protected cell companies, then we can, and that means that you have your umbrella fund where you can set up separate sub funds underneath. There is no limit to the amount of sub funds or cells that you can create, and as at the risk of stating the obvious, it's very very good option for multi-strategy managers, and even for single strategy managers, but that want to have the flexibility of having different groups of investors in different cells. They want to have different fee structures in different cells, and all of this just adds to the offering under our funds regime. Our fund, as Anthony mentioned before, everyone is up to speed with crypto here in Gibraltar. So the bankers, the accountants, the lawyers, of course. But in terms of funds specifically, having fund administrators that understand crypto is an incredible advantage. Our funds can accept crypto as subscription, so it opens up the possibility of attracting investments from players or investors that are already in the crypto space. And there are a lot of people that made a lot of money early on by investing in crypto early on, and they can just use those profits and invest directly without even having to convert into fiat. Use those to invest into our funds. This past year, time flies, we've set up two experienced investor funds, but tokenized, and that has been again another big piece of news, and we're seeing a lot of interest in tokenized funds now. We have our tokenized funds are crypto funds, but they don't need to be. So we are looking at now how we're going to structure other types of funds, your traditional stocks and bonds funds, real estate funds, but having those tokenized as well. So there is a crypto angle to what would traditionally not be a crypto fund. And in terms of tokenization, again, we are doing a lot of work with setting up token issuers. We register them as VASPs, as Anthony mentioned, but those are for utility, for what would maybe not you. Sometimes we don't like to use the word utility, but for non-security tokens. In terms of security tokens, again, we have another success story out of Gibraltar, and that was again 18 months ago. We had the incredible announcement by the SEC that they had approved for retail offering an offering under none of the exemptions. They had approved the INX token. And the incredible thing there was, apart from the SEC actually allowing and approving what in essence is a crypto-based security to be offered to the retail public, knowing how notorious the SEC had been or continues to be in this space. But the incredible thing was that INX Limited, the actual token issuer is a Gibraltar company. So we represented that company, and so that was amazing for us, because it was the first, it remains the only security token to be approved by the SEC. And it wasn't even a US company, it was actually a Gibraltar company. And with that came the forensic analysis that the SEC did on our laws and our regulations and on the entity itself, which even though we had a lot of rounds of feedback with the SEC, there were never any major sticking points in that process. And then finally, at least for this bit, is mention the foundations. Again, we have set up in the last 12 months several foundations, and these foundations are set up primarily to support DAOs, so to support decentralized protocols. Anyone in the crypto space knows how difficult it is to when anyone tries to marry the decentralized space with the real world, let's say. Our position is generally that it's not possible. But what we have is, or what we have done for clients is, we've set up crypto foundations, which act as support systems to these DAOs. So they are set up with a view to working for the benefit of the protocol, and it will do anything that it is allowed to do for those objectives. And that may be as simple as just contracting and paying for the next booth, for a booth at the next conference, but it may be more. It may also be things like contracting with advisors, contracting with developers, opening bank accounts, and that type of thing. So it's something which we have offered to clients as or we have worked with clients with foundations, but we have found that some clients have come here, they've set up a crypto foundation, they've set up a token issuer, which issues the native token of the protocol. They've set up a research and development company as well, which does one thing and one thing only, and it's to develop the contracts and develop the code and the software. But then also we found some founders of these projects actually looking at Gibraltar for them to move over. So it's almost a holistic service and a holistic offering that we have in Gibraltar, which is why, of course, we called it the go-to destination.
That's right, not the to go. No, and it's interesting, of course, because Gibraltar as a common law jurisdiction didn't sport a foundation vehicle until really relatively recently, wasn't it? It was 2017. And so, we've been very quick as a market, I think, to find an opportunity to apply a foundation in a way that perhaps we weren't contemplating when we created the foundation, which of course speaks to the private client focus of Gibraltar as a jurisdiction in terms of offering products that clients from different types of jurisdictions, civil law jurisdictions especially, will recognize, and all that's been very, very interesting. But I thought we could come back to the work that you're doing in terms of the DLT licensing and the regulatory work that you're doing. You touched earlier on how there's now the focus on the VASP registration, which is a more recent development. And for me, not being involved in the day-to-day the way you both are, for me really the question is, where are we as a jurisdiction from a licensing perspective, given that we have 15 licensees and another 15 applications on the go? Is it easier or is it harder in 2022 than it was to successfully apply for a license in 2018? Bearing in mind, of course, that there was an element of grandfathering for entities that were already operational at the time. Yep. when it bit. Is it easier? Is it harder? Is the experience of the Financial Services Commission, as they go through all these applications, starting to yield a return in terms of their openness or their understanding of projects as you approach them?
Yeah. I don't know if it's easier or harder. It's certainly an evolving process. And as Aaron mentioned earlier, we have a very good relationship with the regulator. We deal with them almost on a daily basis. So you establish sort of personal relationships with them. In fact, we just got off a call, team call with them just before joining here. And these calls are very important to, to establish, okay, what are your sticking points? Where are your concerns? Where are your issues? Because obviously sitting on the client side of the fence, it's difficult sometimes to understand, where they're coming from, what are their concerns and issues. So it's good to have these conversations so that we can understand where they're coming from with certain questions or problems that they may raise, but also so that they can understand, from our perspective, it can be very frustrating if you take long to respond, or if you ask questions, the same sort of questions time and time again. So, it's very important. Communication is key, I think, with the regulator, and that is something, luckily, that we enjoy. But going to your question, obviously, when the application process was first made available, and people applied, we helped a lot of clients apply, and there was not a lot of guidance around what the application should consist of. So, and I sensed that the regulator, to a certain extent, was making it up as they went along, right? So there was the application form, but then there's the whole suite of policy and procedure documents that you're expected to also submit, and that wasn't set out anywhere. So it is difficult, especially with something that was completely new. Although it's very similar to the other regulatory frameworks for financial services activity, the same sort of principles that you'd expect to see. So safeguarding of customer assets, corporate governance, capital adequacy. It's the same sort of things that you expect to see with a financial services application. But there are certain nuances that may not apply for with any money firm or with a payments firm that apply to a crypto firm. So, for example, the safeguarding of customer assets on an EMI is completely different to the safeguarding of crypto assets, and whether it's on cold storage, hot storage, what is the consistency, the ratios. So
and I imagine a lot of what you do, a lot of the value that we as a firm might add to, say, startups, because I mean you deal with a range of clients, from startups to established and well-known brands, but I imagine you'll be adding a significant amount of value to startups, often entrepreneurs who have an idea for a project but really can't go beyond, because I mean a lot of this is, a lot of the entrepreneurs in this space are very terribly single-minded about the crypto and the project itself, and may perhaps be less aware of the business environment, commercial, legal environment, and the considerations they need to bear in mind. So is it right to say that a lot of the value that you add, certainly into the startup space, is in that initial review and evaluation of the project, and perhaps guiding, cajoling, structuring as well?
Definitely, and that's probably the one of the areas that I find most enjoyable, right? It's you get a client comes to you, saying, this is my business plan, this is what I want to do, and you have to provide feedback saying, look, okay, if you want to do it this way, this is what applies. These are the regulatory sort of parameters. These are the sort of things that you should be considering. But there may be issues. So, for example, if it's providing services to the retail public, and you think that the regulator may not sort of find that very attractive, or may find that it's not within their risk appetite, we may say, well, actually, have you considered perhaps limiting this type of service or this product only to experienced investors, because we think you'll have more joy with the regulator on that, if you sort of structure it that way. So it's never boring, I can tell you that. the sort of business plans that we see and the models that we see, are so different and intellectually stimulating when you're trying to look at the regulations and whether something falls within scope or not.
Yeah.
So yeah, that is part of what we do for sure.
From the in the context of the 9 principles of the regulatory environment as it exists today, looking back now with the benefit of 2020 hindsight, did we do the right thing in terms of, I mean, it strikes us quite naturally that it was the right thing to create an environment which was outside a sandbox and didn't provide those very strict limitations for businesses that are starting to venture their way out into the world. Did we get the balance right, do you think, on reflection now for the last 3 or 4 years on pitching it the way that we did? Is there something that perhaps we could be looking at doing better, based on all the experience that you've had so far?
I certainly think it was the right balance. The focus was always on proper regulation and not just getting people through the door with a quick filling of a form and payment of a fee. It was very important to us to maintain the reputation of Gibraltar as a reputable regulator in financial services, and I think we did get the balance right, because the aim was always to make sure that we had quality over quantity. We didn't want hundreds and thousands of firms. We wanted the firms. It doesn't matter if it's a smaller pot, a smaller number, as long as it's the right type of applicants, the right type of licensees that you want to be associated with Gibraltar, right? So I do think we got the right balance. I do think we spent a number of years putting it all together. It wasn't a quick fix, and you see what other jurisdictions have done in the space, and they have tried to create shortcuts or just put something out there quickly which would attract business to their jurisdiction, and in some cases it's backfired, right? Because banks see right through it. So not just banks, investors, other type of partners that you want to be attracting. If you're an applicant, if you're a firm, you want to be attracting the right sort of investment, the right sort of partners. You want to be able to open a bank account, and in order to do that, you get scrutinized. And if you say to and the proof is in the pudding, as they say, when you look at how Gibraltar licensed firms have been able to raise investment from institutions and big numbers. They've been able to open bank accounts around the world because banks recognize the Gibraltar license as a proper license. Whereas other jurisdictions may be focusing on AML and certain things, which is obviously great. But in Gibraltar, the regulatory framework is much more than just AML. It's everything else around it.
And we were talking the other day, Aaron, about how we have been dealing with clients who were looking at other jurisdictions, but in the process of engagement with us, one of the advantages we have, of course, is you don't want to sound like you're too close or too friendly with the regulator, but certainly I think it's important to couch it in terms of if you try and have a meeting with the FCA in London, it's going to be a little bit more challenging than having a meeting with the FSC in Gibraltar, just because I think it's just the size of it, right, and our ability to have that rapport, that connection. But we talked about how there have been clients who've started the process elsewhere and have ended up here because in that process they thought, God, there must be a better way, an easier way, and they've had conversations and they've ended up here. That's your experience, right?
Absolutely, and I think it all boils down to regulatory certainty again. So I think we knew early on, and we've been proven right, that no country or no reputable country will not regulate crypto. Everyone will end up with a framework around crypto at some point. We've seen it with the EU. We're seeing now a lot of movement in the UK. But until that point, there is uncertainty, which means that how is it the best place to start your business and grow your business somewhere where you don't know what the rules are going to be tomorrow? And I think that is what Gibraltar provides. So yes, we took the risk of going full regulation early on, but everyone who looked at Gibraltar knew what the rules are. So you either came here because you wanted to be regulated, and or you didn't. Now, Anthony mentioned we wanted quality over quantity, and that's what we got, and that's why eToro is here. That's why Huobi is here. That's why Bitso is here.
Yeah.
So many, up to 15 good solid names that we can mention. So absolutely, and you mentioned also we never want to say anything that's going to sound as if it's easy to get regulated here,
because it's not, absolutely.
and the regulator will always tell you, look, we will check who you bring to us. We will check if they've been halfway through an application elsewhere. We will check, why are you coming here now? Is it because you were going to be rejected on? So regulators speak to each other. So it's definitely not light touch regulation in Gibraltar. What you have is that you know what the rules are, and then decide whether Gibraltar makes sense for you or not. But the platform is there.
And in terms of, I mean, I don't know what ratio, I mean, of the clients that we've dealt with over the last few years, in terms of in the full range, of course, and it may be relevant in some cases, but less so in others. We found that there's a significant number of crypto entrepreneurs and execs joining these startups and these now beyond startups, established players, well recognized players in the market, who've also come to Gibraltar because, in addition to the attractiveness of the regime, the certainty of the regulatory environment in which they establish, has also proven an appealing place to come for themselves, their families, and not just from what perhaps might be said to be the obvious points on taxation, which of course are relevant, but in terms of lifestyle, location, the legal system, is that what you find in the majority of cases is happening?
Yeah, many times. So maybe not so much for the larger international firms, which are obviously have branches in multiple jurisdictions. Their sort of CEOs, UBOs may be located somewhere else, but it is a requirement of the regulations that we have sufficient substance in Gibraltar. So they are required to either hire locally or relocate some of their top guys, or at least people in managerial roles, to the jurisdiction. But interestingly, what we have seen also now is some of the founders and the UBOs, the shareholders behind these projects and then behind these establishments, moving themselves to Gibraltar with their families. Like you said, I mean, it's obviously that there are many pluses. Gibraltar being such a safe jurisdiction, political stability, lifestyle. Obviously, taxation is a bonus. So there are all these things that make Gibraltar sort of an attractive place to live. And it's actually quite exciting to see the actual founders, the people behind these projects moving here, or actually relocating parts of their team here, because it just adds to the community, the crypto community that we're all obviously very close to. And we've seen over the last few years that it's been growing organically. It's not a quick boom, everybody's in Gibraltar. It's been growing organically over the years, and I think that's the best way.
Yeah, and there's a very strong sense of the development of the ecosystem that you touched upon, which of course is extremely important. The university offers courses on blockchain. We have all the relevant industry associations working together with government and with the regulator in terms of development. What developments, and I'll open it to both of you, what developments do we see on the horizon, or 2-5 years from now in this space? Clearly, there's a lot of noise right now in relation to NFTs and the metaverse and where we might be going in that context, of course, as one of the areas of crypto and DLT that we're looking at. But what developments do you see of substance coming down the line, and how might one, they impact on us, and two, how do they represent an opportunity potentially for the jurisdiction? I think
absolutely. So NFTs and the metaverse are something which we are keeping a very, very close eye on. NFTs already we're dealing with, whether it's a crypto fund that invests in NFTs, or it's a token issuer where they are issuing NFTs rather than tokens or coins. But what I see as something which is going to be very big in the next few years, and it's kind of a bit under the radar now, which is why I see it also as an opportunity, is in the tokenization of assets. So we're looking very closely at tokenizing real estate for starters, but that can be anything. You can tokenize whatever. Each underlying asset will have its own challenges. So, for example, and the obvious one with real estate is, for example, the payment of stamp duty.
Sure.
How does that affect it? So there are a lot of challenges, and there's going to be a lot of conversations with government and government authorities. But the tokenization of assets, I think that is extremely powerful, because it goes straight to the heart of what crypto stands for, which is the democratization of
ownership,
fill in the rest, right? And in ownership particularly. So we spoke about crypto funds, how the regulated ones are experienced investor funds, and there is always in the world of investments, there is always this limit for the retail investors, what they can have exposure to. So everyone knows, for example, a massive development of a building will reap a lot of benefits. Would be a high return of income to the actual developers, but your man on the street will never be able to have access to that investment. Through tokenization, again, it democratizes that. So you can have a portfolio which is just, I don't know, £5,000, because that's all you have. But you have your £1,000 in property, you have your £1,000 in stocks, and that can be achieved very easily conceptually, although it's a bit harder in practice. Of course. But that can be achieved through tokenization, and that's where I feel we have a big opportunity.
Interesting. Anthony, I mean,
I agree.
Challenges. I mean, of course. I mean, I suppose one of the challenges too, right?
One of the biggest challenges is basically DeFi, right? DeFi is basically the idea that there is a protocol, there is a smart contract, or DAO, as Aaron referred to earlier, which is basically a piece of code that is operating autonomously on its own. Nobody's behind it, and billions of pounds worth of assets are traveling through that code. And that is sort of when a regulator sees those things, it's just alarm bells everywhere, right? Of course. So the fact that there's nobody that they can sort of point to and say, this is the person that we want to regulate. So these are the issues, and of course, in the traditional world where AML is always a concern, and the concerns around money laundering are growing all the time, right? It's over the years it's become more and more of a concern, and of an area where the law has decided that it's something that needs to be tackled, and this needs to be measures, processes, individuals that are trained, and it's their role to make sure that none of this happens. So that sort of traditional anti-money laundering, those policies don't necessarily align themselves easily with this new DeFi world, where there's a code which is transferring digital assets, but obviously there's nobody running that code. It's not a centralized model. There's nobody there to say, okay, hold on, where's this asset come from? Where's it going to? Whose wallet address? Who's behind?
But if you're a maximalist, you don't care, because really there's no place for the regulator in the world of the maximalist. So that's the challenge, isn't it? Because you're trying to bridge.
But even if you're not, and we were discussing this just before we jumped on, it's the other challenge is privacy features using DLT. Now regulators, like Anthony said, regulators hear the words privacy enhancing, and it's again red flags everywhere, money laundering scheme.
Of course.
But it is there are a lot of big institutions that are nowhere near adopting operating in the DLT world, because as long as you know what the wallet address, or you have an inclination of what wallet address belongs to, I don't know, the Bank of New York Mellon, you will be able to track each and every transaction that has ever been connected to that wallet on the blockchain.
Yeah.
So the reason that I can't go, Selwyn, into your bank account and see every single transaction that's gone into it is just basic privacy, your basic right to privacy in your financial dealings and financial transactions. So we need to, again, we need to find a middle ground where we can use DLT with privacy enhancing features, but that is AML compliant. Again, we'll give the regulators. So where that's going to come from is that we are working with several clients that have projects that are privacy enhancing. But there are a lot of.
It's interesting, the tensions between, the transparency of the public record, the immutable record, and these privacy enhancing features, which, as you rightly say, in the banking context, is just part of the course. It's only what we expect, and it's certainly going to be a very interesting debate going forward. And again, it's all part of this bridging of the gap between what is still niche, surprisingly, because it just still is, and the mainstream. And there's always going to be the traditional resistance to any change, which is inherent in
the thing. Like Aaron just said, no, it's more than just a debate here. It's
absolutely right. Exploring with how
we're actually dealing with real life cases, real life matters now, and exploring them with the regulator. So we're very open with the regulator.
It's not esoteric, it's a practical thing.
And we may say, look, we think this falls outside of scope, but we understand there may be certain issues. How can we get you comfortable? How can we marry the two? How can we build the bridge so that you get comfortable with what our client is trying to do?
And then as a jurisdiction, we have the flexibility as well, that where once we've had that discussion in that detail, in that granularity, looking at practical applications, we are, by virtue of our size and the ability to move stuff in Parliament, we have the opportunity to make the relevant change. And perhaps Brexit frees us a little bit from some of the constraints, in that sense. Although, of course, for us, the key objective after Brexit in the financial services and regulatory context has been that we are not in any kind of race to the bottom, that we are going to continue to be the best regulated, one of the best regulated jurisdictions in the world, and that is a key objective. I think it's been a very interesting discussion, and obviously there's a lot of matters that we've only just touched upon, because within the context of this, we can't really go into it into too much detail. I think at this stage, all I'd like to do is to remind the viewers for whose attention we're very, very grateful. I hope most of you are still there. To say that we're open to discussions about potential projects or partners or clients that may be jurisdiction searching, or may have a project in a very early stage of development, which is just a concept. Gibraltar as a proof of concept jurisdiction, you won't find a better one. Again, British legal system, common law system, gets to the Mediterranean. There really are many, many advantages. But I think the key thing is that you can always get in touch with us. We're very happy to have initial discussions to sound out a project and deal with questions, because at the end of the day, that's how we've built what we're very proud to call is a very strong DLT jurisdiction, which we hope will only go from strength to strength. I've not been paying too much attention to the screen, so I don't know if we've got questions. James, you'll tell us if we've got some.
We have, yes. While I'm addressing these questions, can I firstly ask you to perhaps share your contact details on the screen? I don't know if you can. Actually, you probably can't, can you? I'll if you have a convenient way of doing that.
You can just go to gibraltarlaw.com, and we're all on LinkedIn as well. And we've been sharing away like mad people the link for the event. So you should find us quite readily on LinkedIn and connect with us that way. We'll be very happy to engage with you.
Okay, great, excellent. We'll obviously contact anyone who is watching this. We'll follow up with you. Look, firstly, thank you very much. Really interesting discussion. I appreciate you've been speaking to a blank screen. I didn't want to distract you by having my camera on, but thank you for dealing with that. So look, some of the questions we've had from the audience, I think one interesting one, I know you touched on this to an extent, but is to move outside of crypto and look at the play tech sector. I know you have some expertise there, or considerable expertise. So the question is asking if Gibraltar is going to become a go-to hub for playtech startups, and how challenging is the regulation in Gibraltar for fintechs in the payment space?
Yeah, so in the more traditional payment space, the model in Gibraltar is very similar as what it is in the rest of the EU, because the Gibraltar e-money regulations, or payment services regulations, are based around the EU directives from when we were together with the UK part of the EU. So anybody that's familiar with the EU payment services or e-money directives will see that our legislation here is very similar to that. The interesting thing about Gibraltar's sort of let's call it traditional financial services space is that whilst we can't now passport services across the EU since we left the EU after Brexit, we are the only jurisdiction outside of the UK that is able to passport services to the UK. So that is something that is quite popular, and that one of the reasons why we see applications from e-money firms or payment services firms is because they want to access UK markets as well as other markets around the world, but they find Gibraltar as a jurisdiction where they can set up. Obviously, from a tax perspective, it's quite competitive. From a regulatory perspective, it's easier to approach the regulator. So in a way, it's probably cheaper as well to rent office space and to hire people here than it is in the UK, and therefore it's quite attractive as a jurisdiction where people can set up and apply for licenses and have access to the UK market, as well as obviously other jurisdictions outside of the EU which don't have restrictions, and so it is quite popular for those reasons.
I mean, I see a question there from Seema about what are the challenges faced in Gibraltar in the play to earn space. I mean, that's an exciting, very interesting space.
Absolutely.
I suppose what the challenges are depends on the angle from which you're looking at it, whether as the developer or as the user. I don't know whether you have any insights in that regard.
Yeah, absolutely. So we've been speaking to many of them, many projects, many play to earn projects, play to earn games. And so there's nothing stopping you from setting it up in Gibraltar. What we're finding is the biggest issue is one with the sale of NFTs that you use in the game, because these tend to be of fairly low value, and generally the gaming community is just used to purchasing these NFTs without having to go through any type of onboarding, producing any KYC, AML. But the problem that we have with the law, and this comes direct from the FATF guidance and international standards, is that yes, perhaps you have an NFT which costs maybe only $200, but if someone purchases 100 of these $200, then you are the amounts become significant.
Yeah.
So there is always, at least the position now is, and we keep revisiting it. You need at least to know. You need to at least attach an identification to each purchaser. So that doesn't happen. So that you don't split up a large amount into many transactions. So that is the first issue that we find. Sometimes that is just a showstopper for these projects. And secondly is the fact that many of these games will be hosting a wallet. And that activity, if done from Gibraltar, requires a DLT license. And the DLT license, again, Anthony went through it, it's a proper license, which, although there's different permissions on the license, but it's the license that you would get if you're a crypto custodian, crypto exchange. So it is a proper license, and sometimes it is above or beyond the reach of these startup games that tend to be, at least at the beginning, smaller in nature. So it seems a bit overkill to go for the DLT license when you're just just developing a game.
Absolutely right.
So those are the two main challenges.
So I would like to add to that, because, and just to sort of put a real life example into it, we do have a client that yesterday received was registered by the regulator here to sell sell tokens in connection with a play to earn game. And the issues that we've had with them are obviously on the KYC side, because as Aaron mentioned, a lot of these are low value items, but there are other concerns. But also two more things. One thing is on the operational side of the game. So if you are if you're running a platform where with play to earn characteristics, where users can play a game and potentially earn or receive rewards for winning, even if it's a game of skill in Gibraltar, that would potentially that would likely fall within the scope of the gambling regulations, because in Gibraltar, games of chance and games of skill are not sort of differentiated in the law. So this obviously could give rise to another set of regulatory principles that these operators would have to abide by. So what's happening is that in Gibraltar, the gambling regulations are being revamped, and in fact, this has been in process for a number of years now, and it's about to be released. But what we are seeing as a workaround to that is that because Gibraltar may be a good jurisdiction for example, for the sale of tokens, but not necessarily for the operational side, because of these issues that we've just discussed. Some people are deciding to sell the tokens from Gibraltar, but then have the operational side of things operated from another jurisdiction, from a company in another jurisdiction, which may not have these sort of overly burdensome regulations around games of skill, for example. And to the extent that because as Aaron said, they may not be ready for that type of regulation yet, but it's not to say that they want to avoid it. They may still be interested in it, but they just want to wait, grow, and to a certain level before they can do that. So they perhaps will set up the operational platform through a different jurisdiction, and in parallel they may start talking to the regulators here and say, okay, we want to eventually be licensed here. We don't think we're ready for that yet, and therefore we've moved this side of the business to another jurisdiction. But we really do want to start the dialogue with you guys so that we can eventually become regulated if we decide that when we decide that we're ready to go down that route.
Yeah, and there's an interesting question as well from Chris Riley. How do you regulate the NFT space with a complete lack of KYC on the majority of platforms? Can Gibraltar be a home for these projects? Well, I mean, I think the first most general observation to make in relation to that is that Gibraltar clearly made a choice to regulate, and therefore at this time and for the foreseeable future, I mean, I can't see that there would be drivers or imperatives that would make us change our view of how it works, because it's worked so far. Platforms that are operating on the basis of no KYC will not be able to make a home in Gibraltar. That doesn't mean to say that there isn't a part of the industry or scope for players in the industry to determine, as many players already have, that actually regulation is not a bad thing or a dirty word, and that it actually opens the door to participation from users that might otherwise, not come to your platform. And in the regulated space, then obviously you might be looking at the potential for users who have who have more at their disposal in terms of for investment in NFTs. I don't know what you guys
Yeah,
would say in
absolutely.
that, in that regard.
I think there are marketplaces out there such as OpenSea that would struggle to operate out of Gibraltar.
Yeah.
To put it lightly, because of the requirement to be onboarded and carry out KYC and AML on your users. But then you've got the example of someone like Nifty Gateway, who does do onboarding before you can use the marketplace. So I think if there's a marketplace that just refuses to do any, and this is in response directly to the question, refuses to do any AML KYC, again, Gibraltar is probably not the home for that particular project.
Yeah.
Okay, great. We have a few more questions. I don't know if you have a few more minutes, guys.
If you just let me pause the video a sec.
Yeah, sure. You can all look at the backdrop of Winston Churchill there.
Yeah, sorry, I'm a fan.
I look forward to this big reveal when you come back. Here we are.
Yes, we're happy to carry on by all means.
Okay, great. So you've covered PlayTech. Let's go back to PayTech, so payments technology you were discussing earlier. Someone has asked about the Middle East. So you said earlier that a home in Gibraltar offers easier access to the UK. But the questioner is asking, what about those who are looking to access markets in the Middle East? Is Gibraltar a good destination for people who are looking to tap into Middle Eastern markets? And how do the regulations around payment technology in Gibraltar compare to those of, say, the UAE? I know you're not necessarily experts in the laws of the UAE, but do you have any thoughts?
That's a good caveat from which to start. That's a good caveat from which to start. I mean, dealing with the Middle East has its challenges as part of the equation, and it's something that certainly from the UAE perspective would need specific advice. Certainly, as a jurisdiction for accessing users around the world, Gibraltar is, we believe, one of the best jurisdictions. Certainly a leading jurisdiction, but we've had similar issues in relation to US-based users as well, where particular projects have sought, for reasons of wanting to avoid falling within scope of the SEC, and we know how challenging that can be, where projects might be developed to specifically exclude, to the extent that people don't get around these controls, US users on the platform. Again, I don't know whether there's something you can add in that.
So the starting point is always asking the client what is your target market, and depending on that, we can advise accordingly. It may be that Gibraltar, setting up in Gibraltar gives you access to certain markets, but for example, if somebody would come and say, we specifically want to access this market, one of the first things we would do is reach out to lawyers, to colleagues in those jurisdictions, and obviously we have networks of colleagues and lawyers around the world that we work closely with in every jurisdiction. Not Hassan's, because we are only based in Gibraltar and in the south of Spain. But so because of that, we have had to sort of develop relationships with firms around the world and continue to do so on a daily basis. So if there's something like that where a client is very adamant on a particular market, the first thing we would do is bring in lawyers from that jurisdiction and say, look, work together with us. What are the potential issues in that jurisdiction were we to set up here and apply for licenses here for the purpose of applying, sort of reaching out to that market.
Okay. Tinsley Lockhart has also asked if you can comment on any potential cybersecurity threats that may get triggered by tensions in Eastern Europe, and the legal protections that are on offer there.
Well, in terms of, sorry.
That's it's not something I could usefully comment on. It's certainly not my field. I mean, the cybersecurity threat status around the world is something that I'm afraid is beyond my remit or areas of expertise. No doubt, everybody's doubling down on cybersecurity and investing in that because clearly it's a developing threat and a threat that's only ever going to get worse, whether or not there are specific concerns about what the current tensions on the border of Ukraine and Russia might generate. It is certainly not a matter I can comment on, but I do know that part of the process, or part of the applications process, part of the focus of the Financial Services Commission on any application is on the robustness of systems and protections, and cold storage versus hot storage for protection of customers' assets. And that is one of the key principles that underpins the process for obtaining a DLT license in Gibraltar. And so by virtue of the fact that we have that requirement, by virtue of the fact that we have to comply with that principle, we are certainly, as a jurisdiction, not in any worse place than anywhere else from the perspective of investing the right level of resource to maximizing the protection for our customers. But beyond that, I don't know that I can usefully and legitimately comment on that.
Okay, well, as a final question, let's jump back to something you can comment on. Someone's asking about the potential red flags that regulators are likely to look at when they're monitoring crypto transactions in Gibraltar. Can you give us any indication of what these might be?
Yeah, so I mean, on the KYC and AML, ongoing monitoring of customers and ongoing monitoring of transactions is very important. And when a regulator looks at an applicant's KYC and AML policy, for example, they will want to see that these things are addressed. Okay, so how are you managing? How are you able to monitor, transactions on the blockchain, or transactions that are not on the blockchain? So transactions that are coming through the payment space. They'll want to know which tools you're using, which service providers you're using. So, for example, in the blockchain space, Chainalysis is one of the ones that everybody uses, or CoinFirm. There are different service providers and solutions out there. And the regulator wants to know who are you using, and who's responsible for the relationship, and that sort of thing. And and funnily enough, in all the applications we see, you always come across the same sort of names, the same sort of service providers, because they're the more reputable. They're the ones that have developed and have a better service offering. So you tend to see the same names, and I'm talking about Merkle Science, Chainalysis, CoinFirm, and these sorts of players.
Excellent.
Sorry, there's another. Sorry, there's quite a few questions, which is great. So sorry, did you want to deal with a particular question?
No, it was James. Which one?
Which one did you want us to deal with? Sorry, James.
I'm choosing with that. So this seems like a nice, precise one. Someone's asked, are there any requirements for any of the beneficial owners of the startup to be resident in Gibraltar? If so, what options, if any, are available to them?
Well, I think there's two angles to that question, and that is from the licensing perspective of setting up the DLT provider, and then the wider discussion around benefit to being in Gibraltar as either a category 2 high net worth individual status, or as a British citizen that has an automatic right to reside and the tax environment in which they operate. I'm going to I can comment in relation to that latter element in terms of the advantages of being resident in Gibraltar, and that is a tax efficient jurisdiction. Certainly we pay tax. I mean, standard tax on income up to 50,000 is 25%. So we are a relatively low tax jurisdiction from a personal income tax perspective. The maximum rate is only ever 28%, but soon starts to tail off. We also, in addition to that, have specific regimes for higher executives possessing specialist skills. Yes, it rolls off the tongue, the HEPS regime, where you are taxed on a maximum income of £160,000 a year, which totals effectively 30,000 in tax in a year, regardless of the total amount of income. If you're a high net worth individual as well, you can come to Gibraltar and apply for category 2 status. And that means that if you have a minimum audited net worth and you have the relevant references and take up qualifying premises in Gibraltar, you'll pay a maximum tax on worldwide income of around £40,000, regardless of how much that worldwide income is. So those are the special statuses. I mean, even on the standard income tax levels, we're very, very competitive. Corporate tax is at 12.5% here in Gibraltar as well. And so, can the beneficial owner of a startup in Gibraltar not be resident in Gibraltar? I think the answer is yes. It's just that the FSC is going to want to have a human person that they can poke if anything, in terms of.
The answer in short is no. A beneficial owner doesn't have to be of a startup, doesn't have to be resident in Gibraltar. Any company you can, there's no legal requirement for the shareholder or UBO to be based in Gibraltar. Not so much the case with directors and key role holders. Some of those will be required to be in Gibraltar, but not the UBO. So a shareholder doesn't have to be here.
Excellent. Look, I don't know if you've had a chance to look at the questions, but perhaps the place to end here.
Yeah, we're looking at them now, actually.
Yes.
Okay. Take the Valerian one.
Yeah, I think we can cover two of them very quickly. I think the question on the Valerian deal with GSX, if this is going to be a significant development, is if the vision is executed as they propose, then it will be. One of the biggest issues with tokenization and security tokens is the fact that there aren't really any good options now, any security token exchanges out there. If we get a security token exchange here in Gibraltar that has volume and takes off internationally, then I actually put a post on LinkedIn, I believe it was yesterday, I really think it will propel us once again and keep us way ahead of the curve in terms of a crypto jurisdiction.
And there's another question here of whether other countries are looking to mirror DLT regulations, or whether this is the proof of concept they will look to. We'd very much like to think that it is a proof of concept that is working. We almost took a gamble, although that's probably the wrong word. We took a punt on this being the right approach, and I think that 4 years in, we're pretty satisfied that it was the way to go. It was easy enough for us to go this way because, of course, we are fleet of foot. We are a small jurisdiction, and we will not be dealing with volumes the way other jurisdictions will. Certainly, you look at the European effort, and it's obviously entirely a different proposition altogether in terms of its reach, its scope, and the issues it needs to deal with. And so I think that absolutely other jurisdictions, as Aaron said, inevitably all jurisdictions will end up having to regulate crypto one way or the other, and ours would not be the worst model to start working on for many certainly small jurisdictions out there.
I think that they will. I think that most jurisdictions will be forced eventually to have to regulate this industry at a similar standard than the traditional financial services world, which is what we're doing. So we've basically got the traditional financial services world and said, okay, these standards work for the traditional financial services. Let's apply the same sort of principles to the crypto world. And I think, as Selwyn said, I think it's served us very well, and I think it's been very successful. And I do think that most jurisdictions will eventually go down that route as well.
Excellent. Okay. Well, unless there are any other questions that you've spotted there that you think are worth addressing, I think we should probably wrap it up there.
There's a final one on the predictions for crypto funds. We've already seen one of our funds switch from a regular fund investing in the top 10, top 20 coins to a fund that focuses in the play to earn space. Funnily enough, going back to one of the earlier questions, and I think there's going to be a lot of focus by crypto funds in we're focusing on the metaverse and everything that entails and is connected to the metaverse. That's my feeling with crypto funds for the next few years.
Excellent, great. Well, look, thank you all very much. That was a really fascinating discussion. Thanks to you and the audience for joining us. We will contact you after this. Huge thank you to Anthony Provosoli, Aram Pass, and Selwyn Figueres for their time. Thanks to Hassan's law firm, obviously representing them. But thanks for putting on such a fantastic discussion. Cheers.